Hello and welcome. This is Grant Hughes of Grant Hughes Investigates on YouTube. This channel evaluates all aspects of true crime. As you are aware, videos and live streams in this genre often discuss elements of crime that may be disturbing to some viewers. If necessary, take the precautions needed to avoid these feelings. Factual information related to cases is the key to fostering rational true crime discussions. Fortunately, you will find that here. Please hit the like button only once, share the video, and subscribe if you like my content. Thank you very much for watching.
5 brain cells, 4 aren't working. Have you lost the last 3 brain cells, or do you just have cabbage for brains? Stupid is being nice. You're an absolute moron. Did you hear what I said? There's mosquitoes the size of bald eagles in that dadgum swamp.
Huh? It's a house!
Hey! What's going on, freaks? Hey, thanks, Cheryl Bullock! Hey, look at she's laughing over there. Can you see that? Alright. Yeah, so on the video earlier today, if people are confused, so let's see, what was it? Stephen Stearns, remember he leaves the house in the morning, and 8:31 is the last time he was there, leaving the complex. He does not have his cell phone with him at that time, and then he actually makes it back there at 10:44, and Jen is over at the doctor's appointment at that time. So he makes it back to the apartment. Now he has his phone. Then he takes his phone with him this time when he goes to the vape shop and everything. And then he comes back home, like at 11:57 or something. And then at 12:50, he leaves intentionally, leaving the phone there again. So twice in that same day, he intentionally left the phone at home, and then he put Maddie's body by the bamboo shoot. Somebody out bamboo trees. Somebody goes, "That's not a bamboo tree, Gray. That's not a bamboo tree." Yeah. I'm pretty sure they are. Pretty sure they are, although I'm not a botanist. Or arborist, or whatever the hell the term is. I think they cut down, I don't even know. Shit. But anyways, yeah, so then when he gets back home, and he gets to his phone at 12, I think it's 2:47, that's when he calls Jen up and apologizes for not being home on time to go to pick up Maddie together. That's when he called, right? So hopefully if you're out there and you're one of the confused people, there you go. I think it's about time to do debunking videos. There's so many people that have such a strange, it's like almost like there's other YouTubers out there telling them stuff that they believe instead of actually reading the documents. It's weird. Like for example, everybody keeps saying, she says we. Did you hear her say we a couple times? She said we dropped them off. But how about you also show that like literally 30 seconds later, both times, she says, yeah, my boyfriend dropped her off. Both times. Okay, so that negates your attempt to say that she's lying, because she immediately corrects those things. A lot of times people just say we, right? So she corrects those. And what else is out there? And by the way, the whole thing about her seeing Madelaine at 8:15, we don't have it like it's a quote, the thing is, that's in one of the early documents. How do we know she didn't say the same thing and the officer who transcribed it was like, oh yeah, she saw her at 8:15? Because every time I read it in this 900-page document right here, she said she didn't see her after 11 o'clock at night. Did you notice that? Pretty wild, pretty wild. So I think it's time to go through and just make a video or something where you just pretty much show each element and try to get people to say, oh, okay. But they always still land on, they say stuff like, God, she's so disgusting. She sent her child to be with a predator. And I always think to myself, what do you mean? She didn't know he was a predator. So what do you mean? You're saying something that, you're almost assuming like she knew he was a predator and just, it's just wild. The comments people make, it's just, it's almost like they're just so feverishly want to prove that they're a better mom, probably doing, shrooms and snorting coke every day, but as long as they haven't let their kid be taken over by a predator, they're better than they are. Yeah, I know. I'm just saying, when you watch, you see the timeline and her behavior and things she was saying, she looks like she's a concerned mom looking for a kid. Okay, and then people, what is she talking right now? Well, would you? Knowing how you guys treat her, would you say a word? Hell no. And I say you guys, the people I'm talking about. Right, yeah. And then like Zozo at the end of the show last night, there's a portion in these documents where this a girlfriend that Stephen Stearns just had recently, like last year, he was seeing on the side, she's the one that told the story about how he said, he would sleep with Maddie, and sometimes he'd wake up, a little excited or something. And she broke up with him. How come she didn't tell anybody? She didn't say a word to a soul. That might have made a difference. Let's see. And I'm not even, so that person knew something was going on. So it's like, wow, how come he didn't say something? All right, but the world shouldn't be going after her either. It's all about Stephen Stearns. He's the bad person. Where was Stephen going before the tire blew? He said, we don't know where he was actually going to go. He made up stuff about he was going to go to these gaming shops and everything, but that's total bullshit. He was maybe going to put her body, maybe he was going to put her body in a lake or pond or something like that. Don't really know. But don't you think it's been 4 months now and they haven't arrested her or charged her with anything? That they really just haven't been able to find something directly linking? I mean, don't you think they have enough on Stephen Stearns right now? They don't need her for trial, okay? I mean, they have enough on Stephen Stearns right now he's never going to be out of prison ever again. They don't need Jennifer Soto for a good case. They don't even need her. She could fall off the face of the earth tomorrow and it wouldn't affect that case at all. There's all those photographs, the image, he's putting her in the trunk. He's the one that drove her over by, the bamboo trees and put her there on, I think, what was the name of that road? Old something. I don't know why I can't remember it at this second, but let's see. He did all those things. Old, isn't it Hickory? Yeah, Hickory Tree Road. There you go. It's actually Hickory Tree Road, not Old Hickory Tree Road. Well, I'm showing it on the screen if you were wondering. Kind of still looking at the main monitor here, but it was right there. Yeah, so they don't need her at all. So let me ask you this. You don't think that if they found some little element that pointed that she knew that Stephen Stearns was doing stuff, that they would have just arrested her immediately? Because they don't need him at all. They don't need her at all for his case, and they don't need anything. There doesn't need to be any cooperation or anything. They've got every bit of information they need to have right now. So it's not like, they cut a deal with her. What for? They don't need a deal. No, she didn't, Lisa. She didn't. You can say it 100 times. I know you got one of those free memberships, but Listen, you can say it a million times, but she didn't know. Okay? You can say it 50,000 times, but there's no evidence whatsoever saying that. So when you're saying that, it's just you trying to pretend that you know. If it's a ring for trafficking, they do need her to testify. Sure, no, but they can still charge her and say, listen, we're going to charge you, but we'll cut you a deal. I just don't agree. I think it's really obvious. She knew Gray. How about this? Give me one piece of information that can prove that she knew. And the answer is you have none. You just want to believe, therefore she knew. I'm not upset at all, PG. I'm actually in a good mood. What are you talking about? You sound kind of off yourself. I feel good. Not sure what the hell you're talking about. I'm just explaining different things that people comment about out there. I mean, did my face look like I was upset when I was on camera a second ago? Jesus. I just started the show, 9mm lipstick. I mean, literally like 12 minutes ago. Do you think I got through all the document in 12 minutes? The evidence is that she sent him to bed with him. Okay, what evidence? Why is that evidence to you? She didn't know that he was a predator. I mean, you're insane, Lisa. That's all there is to it. You're insane. Let's see. The most they have her on is child endangerment. They don't even have her on child endangerment. Because see, what you're assuming is that she knew he was a predator. If it was a family, you know, he was like a family unit, part of the family unit for 7 years, in and out, friends, you know, and was part of the, and, you know, allowing them to sleep in the same bed doesn't mean that, I don't know, you guys. I know it's not ideal, it's not what people do, it's kind of weird, but you saying that it is willfully endangering her is not correct. You don't know what the hell the situation was at that house. I know it's like not something normal parents do, you know, like, but Stephen Stearns is a predator who made the situation seem like that. Right? Yeah. Let's see. Hello and welcome. Just coming in. Please hit that once. Thank you. No, she should have known either to know. That's not how it should be either. She shouldn't have known. They were together for 7 years. He was considered like a stepdad at one point. So she shouldn't have known he was like that. She didn't know that he was a predator all those years because of the grooming and, you know what? I'm not going to do this again. We've already gone over this, explained it 50,000 times. It's very simple to understand. And if you can't understand it, then I just will be spinning my wheels, okay? Go look it up yourself and see what these guys do, and you might be able to figure it out. Jesus. It's unreal. Anyways, let's get to the, we're just going to do the Delphi documents. Now. Yay, what? It's so disappointing. People's brains. All right, here we go. But great. Oh, by the way, 8675309. She sent me this. I guess it's the crash expert in the Karen Reed case. Man, I tell you what. Let me show you something on YouTube. I'll show not that, but watch this. Yeah, that guy sounded just like this person. Listen to this.
Hello everyone. Well, the Ball State softball team continued to play this weekend, and they were hoping to continue off of their straight 3 out of 4 losses. And so we'll take a look and see how that happened. They started off good, but then eventually the Ball State women's team shut down and ended up doing poorly. Oh no. And it's working. Okay. We're going to continue on now. And the Ladies Cardinals will play an Iowa tournament starting this Friday.
This guy.
Before the Ball State baseball team kicks off its conference season this weekend, the Cards will battle an in-state rival Indiana tomorrow. Tomorrow's game will be the meeting between the two, beating both first.
You could hear him listening to him in the background. And then, what's going on here?
Hoosiers are on the 4 on.
Hoosier on the 4
on the year, and they have won 6 of its last 7 games.
This is a car expert right here. This is what he sounded like.
At 3 p.m.
It's incredible.
Switching to Ball State men's tennis, it seems last week player on. It seems every week they have a player. Matt Lawrence is the latest Cardinals tennis player to win the award. Lamar won all the singles and doubles matches last week. So far, the Cardinals have had a player.
By the way, I looked this guy up. I spent a few minutes, and he turned out to be a pretty good reporter. But man, this is like when he first started off. Just look at this crazy stuff.
Honored on the weekly awards. 7 out of the 9 weeks. The Cards will play at Boise State Invite.
Now there's the Pacers up there. Watch.
The Indiana Pacers are looking for a measure of revenge tonight against the New Jersey Nets and to strengthen their playoff hopes. The Nets won the last Sunday's matchup 94-85, which left the Pacers 1 game behind the Chicago in the 7th series spot. Let's check out the highlights.
Look at it. He doesn't know the people's names or anything.
Steven Jackson's David. Reggie Miller's looking good. He shoots a 3, and it's good.
But that wasn't Reggie Miller. That was the other team that just shot the ball.
Later, he gets the rebound, passes it to the man, shoots it,
the man,
and boom goes
the man. Dynamite. He doesn't look at it. His whole thing was wait. His whole thing was waiting. He wanted to say, "Boom goes the dynamite." Watch this stuff.
Later, he gets the rebound, passes it to the man, shoots it, and boom goes the dynamite. The final scores ended up with the Pacers 63 to the Nets 61. The Associated Press of the All-American first team in college baseball was announced today that Utah's 7-foot sophomore center Andrew Bogut was the leading vote, receiving 61st place votes.
Those are good players.
Bogut, an Australian native, received
Bogut,
very little attention in the
JJ Redick and Chris Paul
preseason,
on there.
But averaged 20 points and 12 rebounds a game for Utah. The 4 other players joining Bogut on the AP team are senior forward Wayne Summers and Kansas, and Hacken Warwick of Syracuse, junior guard JJ Redick of Duke, and sophomore guard Chris Paul of Wake Forest rebounded out the list.
Here it comes. And boom goes the dynamite. Look at this right here.
Let's check out some of the scores tonight.
Let's check out some of the scores tonight. He doesn't say a word. The best part is the end, though. Watch this. Watch this. Watch this.
Okay, great. Thanks a lot for that look into sports, Brian.
Yeah.
And when we come back, we'll have one final look at weather. Stay tuned.
Oh, God, that's just so amazing. that's almost like a cliche scene, like at a news station, like, and whoa, you got to admit that. But that's exactly how the witness for the state came across in the Karen Reed case. The car, the crash reconstruction expert. I mean, he was so bad. It was. I mean, you watch him for 10 minutes and you're just like, this guy's one of the worst people you've ever seen in your life. Why are you confused, Daphne? You seem to always be confused when you come in. It's weird. Not sure why. Nobody else said that. You know that? Notice up there everybody's smiling and laughing and kind of got it. Yeah, I mean, it was absolutely incredible. That judge should just do a directed verdict in like 2 minutes. Like the second you just offer it again, and she should do it like right away, immediately. Thanks, Donna Aldridge. All right, now we're gonna get to the Delphi doc and the introduction and learn, go the witness, defense, and then God, also you should have seen this guy. He was so even the witness he was trying to read his notes because he couldn't he really couldn't just speak on it because it was in his mind. So he kept looking at his notes, and the judge goes, "No, you gotta give us your opinion. You can't read your notes." And he kept like glancing down at him, trying to still read it. And she goes, "Hey, listen, just ask an easier question or something." Yeah, it was just, God, how ridiculous was that? And boom goes the dynamite. I actually added that as a. I was kind of waiting for the expert to say at the end, and boom goes the dynamite, but he never did. It was weird. Definitely expected it, though. And boom goes the dynamite.
Stupid as...
Anyways, all right, you guys ready for the Delphi document now? And like I always say, if you're out there and you're able to help support the Grant Hughes Investigates YouTube channel, I would appreciate it. I know we're not, at this point in the show talking about the Madelaine Soto case, but maybe at the end, if we have time, we can open it up for that too. 5 brain cells, 4 aren't working. Not 4, 3. Same thing, I guess. Thought he was going to cry. I didn't watch it. Yeah, there was like another. It went on for hours. It looked like, but I just saw enough where I just realized that guy wasn't supposed to be up there. I mean, it would be on appeal turned over. Like just based on that guy's testimony, it would be reversed. It was so bad. All right, here we go. This is the accused's response to this court. This is going to be reading, you guys, so you know what happens when I'm reading. All right, so just remember to help support the channel even though I'm reading. Notice a conflict in support of said motion. Mr. Allen states the following. So this is regarding, let's see. Comes now, accused Richard Allen by and through counsel and files his response to this court's May 31st, 2024 order or judgment of the court and notice of conflict in support of said motion. Mr. Allen states the following. Hey, thanks, snow remover. And boom goes the dynamite. I actually added that sound effect. I'm not sure why I can't see it. Oh, yeah, there's no way to get to that page. That's funny. But here it is. I have it right here. It's.
And boom goes the dynamite.
See, I have it.
And boom goes the dynamite.
And? Yeah. That's weird. I didn't put an arrow buttons to get to that page. It's kind of funny. I'll have to adjust that later. Thank you, 8675309. All right, on May 31st, 2024, this court issued its order or judgment of court concerning the defense request to have Judge Gull disqualified. So they're responding now to her response. I mean, it's just a never-ending game with these guys. Contained in said order were several errors. The defense is filing this motion to preserve those errors for future courts if needed, and to notify the court that due to new information learned in her order, a conflict has been revealed, which has caused Judge Gull to become a witness. Oh boy. Oh boy, here we go. The defense files this response and notice for purposes of maintaining a record and does not wish for the pleading to delay future hearings from taking place, particularly hearing related... by the way, that witness that was on the stand today, he can't even say words correctly. What the hell was he saying? He was saying, you know the word debris? He kept saying brie. He just kept saying brie. Yeah, there was brie over there. And then the other word was, what the hell was the other one? I'm just going to check. I'm checking the conversation. It was, yeah, definitely. You know the word definitely? He said definitely. I mean, it was really strange. It was like the guy could barely speak. Judge Gull asked she can... but wasn't it similar, Cindy, to that Boom Goes the Dynamite guy? I mean, it's very similar, right? Just kind of like didn't even know what he was saying half the time. He was just... You could see he was cotton mouth. He could barely... also, the defense's response is intended to provide correct information to Judge Gull as she continues to self-evaluate her obligation to recuse herself from the case, should she believe that bias or the appearance of bias exists. Judge Gull failed to inform the defense that Carroll County Sheriff's Office fabricated. Is that right? Man, I don't know. Now I can't spell. Is it, yeah. Let's see. Fabricated. Yeah, I'm just looking at the, this part right here. What the hell what are they talking about? That Carroll County Sheriff's Office fabricated facts in a report filed in her court. What the hell would that be? In his motion to disqualify, Mr. Allen noted that according to a June 14, 2023 report filed by the Carroll County Sheriff's Office, Judge Gull advised the CCSO that it could ignore a valid defense subpoena for Westville Correctional Facility inmate Robert Baston and refused to transport him to the June 15, 2023 hearing on Mr. Allen's emergency motion to modify safekeeping order. The defense further alleged in its motion to disqualify that because of Judge Gull's actions, the defense was without a key witness for the hearing. Ah, God, these guys are just such nitpicking wackos. I don't know why I can... God. And boom goes the dynamite. It was anticipated that at the June 15, 2023 hearing, Mr. Baston would testify as to the harsh, abusive, and unconstitutional treatment of Richard Allen at Westville Correctional Facility. The failure of the CCSO to transport the witness from Westville left Mr. Allen without crucial evidence for the hearing, thereby subverting justice for him. However, in her May 31, 2024 order, Judge Gull claims that she never advised the CCSO to ignore the subpoena and leave Baston behind. Judge Gull's claim contradicts the CCSO report that the court received on June 20, 2023. The June 14, 2023 report, which was ordered by the court, stated the following. On June 14, 2023, I, Special Deputy Wysocki Brian, while on duty, probably Brian Wysocki, while on duty, was conducting transport from Westville Correctional Facility to the Carroll County Jail. Upon my arrival, I was escorted to Baston Robert, DOC number 209210, Segregation Unit, to conduct the pickup. After waiting, a corrections officer approached and told me Baston is refusing to come out of his cell, and told the corrections officer, F you can't make me go. The corrections officer told me they will do a cell extraction to get him to my transport vehicle. I told the corrections officer to stand by, let me make a few phone calls. I was escorted back to the main gate where I was greeted by John Gallipo. I called Carroll County Jail Commander Lori Sestarsik, who I explained the situation to. She then made a phone call to Chief Deputy Toby Lesenby, who contacted Judge Francis Gull's office to inform them of the situation. Judge Gull's office advised to leave Baston there if he did not want to attend the court hearing that is scheduled for June 15th. I then spoke with Warden Gallipo, and he asked if he could provide me with a letter stating that Baston refused to come out of his cell, that he did not want to go. Warden Gallipo agreed he would. He later advised he would bring me the letter on June 15th to Carroll County Courthouse so I could attach it to his report. Nothing further at this time. Yeah, so it sounds like they had a witness to testify at how bad it was for Richard Allen in there, but he said, I don't want to go, I don't want to go. And so he didn't go, you know. Thanks, Michelle H. and Lisa Valenzuela and Justin Oki. The report was approved by Toby Lesenby, who is a key witness in this case. Juxtaposed to the CCSO, I wonder if that's like Carroll County something officer. I don't know what the, I don't know. Yeah, there. Well, no, I don't know what the S is. Security officer, maybe? In which he stated the decision by deputy to leave without the witness was his and was not directed by the court. The first time that Richard Allen's counsel learned of these contradictory stories was in Judge Gull's May 31st, 2024 order of judgment of the court. Judge Gull has possessed this report since June 20th, 2023. God. Upon receiving this report nearly a year ago, Judge Gull never notified Mr. Allen's attorneys of the misrepresentation contained in the report as it related to her purported involvement in the failure to transport Mr. Baston to the hearing. At the very moment of learning that CCSO filed a report with fabricated facts concerning Judge Gull, she should have immediately alerted Mr. Allen's attorneys of the misrepresentation contained in the report. Oh, Sheriff's Office. Okay, yeah, that's Toby Lesenby. There we go. I don't know why. That should have just popped right into my head, but it didn't. Further, upon Judge Gull learning of the misrepresentation contained in the report, which undermined the evidence, Mr. Allen was able to present Judge Gull, never reset the hearing so Mr. Allen could present the very evidence Judge Gull said was lacking when she denied Mr. Allen's emergency motion to vacate safekeeping order. So this is all just about that. How does it make her biased, though? You know, just the fact that somehow he didn't get a witness so that he could claim that the conditions were shitty so he could be transported to another jail. It's just, God, these guys are just, they're... I think Judge Gull was onto something. These guys are piles of crap. Additionally, as this court is aware, Mr. Allen has filed for Frank's motion. And if we all remember, Frank's motion is where there's a hearing and evidence, like they want to have the judge look at the fact that there's errors in a probable cause document or a warrant, a search warrant specifically in this case, I think, where there was false information that led the judge to sign off on the warrant, and had that not been in there, that false information, the warrant would never have been signed. That's what they're trying to get at in a Frank's motion. Also, as this court is aware, Mr. Allen has filed 2 separate motions to dismiss based upon law enforcement's destruction of evidence. One of those motions was heard on March 18, 2024, with the court denying said motion on April 2nd. To prevail on a motion to dismiss as it relates to the destruction of potentially useful evidence, the motion to dismiss requires the defense to prove that law enforcement acted in bad faith. At the March 18, 2024 hearing, defense counsel was attempting to provide evidence to the court that law enforcement has acted in bad faith over the course of the case. At that time, this court was aware that law enforcement had fabricated facts contained in the June 14, 2023 report. What page are we on? 4? All right, let me go. Even if the court would still claim that such a fabrication in a report would not have changed her ruling on the motion to dismiss, the fact is that the defense was not able to include that information on the record for the Court of Appeals. Did I miss this part here? At the March 18, 2024 hearing, defense counsel was attempting, there we go. Yet this court never alerted the defense, and therefore law enforcement's bad faith was not made part of the record. Additionally, had Judge Gull alerted Mr. Allen's attorneys of Carroll County Sheriff's fabricated statement in the report, the defense could have used that fabricated statement when pursuing their Franks motion and motion to dismiss in order to provide additional evidence of intentionally and bad faith on the part of the Carroll County Sheriff's Office. Thanks, Jessica Schubach. Yes, definitely need some more energy in that department. They were just like, let's see. Furthermore, by failing to provide this information, Mr. Allen's attorney, Judge Gull, prevented the defense from investigating this fabricated story, including through depositions. Judge Gull should have alerted Mr. Allen's attorney. Fabricated facts written in their police report will before the March 18, 2024 motion to dismiss, and her failure to do so provides a rational inference of bias. Judge Gull is now a witness in this matter as to Toby Lesenby's credibility. Given that Judge Gull is the only individual who knows that she did not direct the Carroll County Sheriff's Office to ignore the subpoena and leave Mr. Baston at the Westville, despite the contrary assertions in the CCSO report, she has become a witness to Toby Lesenby's truthfulness and to the fact that the information contained in CCSO report is false. The credibility of a witness is always an issue for the jury. It's a ruling at some point. If Judge Gull's story is correct, then she had a ringside seat to the intentional behavior of the Carroll County Sheriff's Office and or the bad faith of the Carroll County Sheriff's Office in that it, 1, intentionally ignored a valid defense subpoena for a defense witness, and then 2, fabricated a story in a police report claiming that the sitting judge on the case authorized the CCSO to ignore the valid defense subpoena. In this scenario, Judge Gull is a witness. At future hearings and at trial, the defense should have the ability to cross-examine Toby Lesenby on these contradictory stories with questions similar to the following. Yeah, I always get nervous when I do these reading episodes because so I guess this is a conversation maybe. Mr. Lesenby, the defense attempted to bring a witness named Robert Baston to testify at a hearing concerning his observation of guards abusing Richard Allen in a variety of ways at Westville, but your office ignored a valid subpoena to bring that witness to a hearing. Isn't that right? You did not, and the attorney said, you did not want the judge to hear the testimony of that witness because it would support the defense contention. That's so ridiculous. That Richard Allen was being abused and should be moved to the Case County Jail closer to both his family and attorneys. Well, why would they care about that? Why would they give a damn about that? You wanted Richard Allen to remain in Westville prison so that he would continue to be housed far from the attorneys and family, while emotionally vulnerable to the abuse he was suffering at Westville. Worse yet, you then lied in a report claiming that Judge Gull advised you that it was okay to leave Basson behind. You lied about it in your report. Judge Gull never told you that it was okay to ignore a valid defense subpoena, did she? I am handing you Exhibit 85, which is the June 14th, 2023 report from CCSA, let's see, in which you claim that Gull gave the directive allowing you to ignore the subpoena. Because the defense is claiming that law enforcement has acted in bad faith, and bad faith is an important component in its motion to dismiss as well as the 4 Franks notices, it must be able to call Judge Gull to the stand to testify concerning the false statement concerning the CCSO's June 14th, 2023 report. Judge Gull's testimony is especially vital concerning the defense motion to modify the safekeeping order, as well as their Franks motion. Why don't they just let him be where he wants to be? You know, I don't really care about that part. You know, they put him where he was because he wanted to be somewhere safer originally. The reason they're doing all of this now, though, is to try to boost their theory that Richard Allen's mental capabilities were diminished when he confessed to his wife and his mother, and they're trying to just really strongly argue this point to try to make it seem like it's a real thing. But the reality is Richard Allen was completely lucid and normal, he was doing okay in prison, he was exercising, he was reading, and then one day he confessed to his wife and mother, and then his wife was like, oh my God, he just said he did it. So then she contacted his attorneys, and then they came up with this ruse to pretend that Richard Allen, well, you know, they had him like wear a shirt with drool on it and start eating paper. You know, it's just total garbage. You know, so now they're doing all this stuff like, yeah, we've been trying to get him switched to another prison. Well, the reason they're not switching him is because it's not true what you're saying, but then you want this criminal who didn't want to go to the hearing to show up to tell people that, you know, he was being mistreated. All right, but hey, you guys, we're on one of those lulls again, so if you're out there, we got to keep on trucking here. We're at 20% currently. I know the show isn't too deep in, but you can already get a sense we're almost an hour in, and that's, I know it's reading, it's not as interesting, but that's all I got for you on this, in these documents. I wish I could have some, you know, a couple hot models read it all for you, but you just got me, all right? Because the defense is claiming that law enforcement has acted in bad faith, and bad faith is an important component in its motion to dismiss, as well as for, I think, how far did we get down there? Calling Judge Gull to the stand to testify as to the fabricated facts contained in the report is especially important when the very witness who is the subject of the report, Robert Baston, would have testified about Richard Allen's treatment at Westville, which directly led to the deterioration, there it is, everybody, deterioration of his mental state and false statements concerning his involvement in the crime. Man, I should have read one more sentence. That's exactly what they were doing. The defense plans on issuing subpoenas and calling Judge Gull to the stand at future hearings, and at trial to testify that she never directed CCSO to ignore a valid subpoena and also never advised CCSO to leave Robert Baston behind if he, Baston, did not want to attend the June 15, 2024 hearing. Judge Gull should recuse herself from this matter as she is now witness in the proceedings. Look at these guys. Look at these guys here. Judge Gull's failure to admonish the CCSO may cause law enforcement to believe that they can create fabricated stories, in this case with no consequences. Despite having the CCSO report since June 20th, 2023, to this day, Judge Gull has failed to admonish the CCSO for filing a report that contains such a flagrant falsehood, which is arguably an attempt to cover up their illegal actions in ignoring a valid defense subpoena. 34. Judge Gull's failure to address that fabrication in any fashion whatsoever provides a basis for state's witness to believe that they can freely fabricate stories which subvert justice for Richard Allen without consequence. This provides a rational reference of bias. Judge Gull continues to errantly accuse the defense of improperly filing ex parte documents. In its May 31st, 2024 order, this court continued to claim that the defense is to blame for ex parte pleadings that were accessible to the prosecution. On March 7, 2024, Attorney Rosie alerted Judge Gull about his grave concerns surrounding MacLeod receiving the ex parte documents. It took Judge Gull 13 days to respond to this urgent matter. In her March 20th, 2024 emailed response, Judge Gull wrote to defense counsel, "I would encourage you to educate your staff on how to properly file pleadings." And they did that. They even sent him something that explained what ex parte meant, etc., etc. I have those too. Attached is a printout from the DocsPop filing process of the February 26, 24 ex parte document that court staff mishandled, causing accessibility of the document to the prosecutor. It should be noted that upon receiving this February 26, 2024 pleading, court staff would see in bold font and capital letters at the top of the pleading the following: ex parte pleading to be placed under seal, which should have easily alerted court staff of the ex parte nature of the document, causing them to follow the proper procedures. You know, these guys are, you know, look what they did with the Frank's memorandum. You know, that should have, that should have been sealed. You know, that information shouldn't have made it out to the public. So these guys have no leg to stand on here. They're just slime balls. It should be noted that upon receiving this February 26, 24 pleading, court staff would see in bold font that, and then which she should have easily alerted court staff the ex parte nature of the document, causing them to follow the proper procedures in processing the ex parte pleading. The staff for the defense filed the ex parte documents correctly. The DocsPop printout shows that the only service contacts listed on the ex parte filings were Brad Rosie and Andrew Baldwin, not Nicholas MacLeod, James Luttrell, or Stacy Diener. Furthermore, the printout shows that all documents were marked as confidential. There is nothing else further that the defense can do to prevent these documents from being made public or misdirected to the prosecution. After the defense correctly files the ex parte document, the defense must then trust that the court staff has been properly trained on how to navigate an ex parte filing, whether it is filed using the Odyssey or DocsPop platforms. In this case, after the defense correctly filed the ex parte motion, somehow court staff erred in how it processed the document into the system, causing the prosecutor MacLeod to have access to the ex parte document. 42. In her May 31st, 2024 order, Judge Gull detailed how she sent the defense a tutorial paper authored by JTAC explaining the process. The court implied its said order that she sent the tutorial. Yeah, she did send it. I've seen it. To the defense in order to assist the defense in learning the proper process of how to file the ex parte motion. Judge Gull's presumption that this tutorial assisted the defense is inaccurate for 3 reasons. 1, the defense was not errantly filing ex parte documents. 2, the tutorial Judge Gull sent to the defense had nothing to do with assisting practicing lawyers on how to file ex parte documents. 3, the defense continued to file ex parte documents in the exact same manner it had been filing before Judge Gull even sent the tutorial to the defense, and there were no issues. Thank you, Amy Moore. Hey, but do the rest of you guys, I mean, here's the thing, you guys. I got to look out for the channel. It feels like people show up and they peel off because we're reading. It's not, I'm reading this because other than that, you guys probably wouldn't even hear about this thing. All right, so I notice how slow it gets in the chat. Nobody's talking. The super chats dry up. It's just really, it's disheartening. It didn't matter what we used to do. We'd read documents and people would do it. But now it's like I got to do the bells and whistles. And thanks, Amy Moore. So, let me know if you guys want. I'm on page 8. There's 21. Anybody? Yeah, these aren't the same. They're arguing about the... All right, but if I'm reading here, I'm going to need you guys' support in, still supporting the channel regardless. Like Amy Moore just did there. Thank you, Amy Moore and Allie K. Yeah, this is pretty interesting. If you're following along, it'd probably be pretty boring if you're just kind of hitting a word here and there. But all right, let's think. The defense was not errantly filing. So they're saying. So let me show you this. It was kind of funny actually. The look at this. Exhibit A here it's almost kind of condescending. I guess they give a form there, but it's really B and C that are funny. Look at this. Like it goes through, it explains the whole system here. Here's how you do it. It says, as a reminder, an ex parte in Latin term means by or for one party. The term refers to, and then it goes through and it shows each element how to file the ex parte document to Judge Gull. Well, thank you very much, Amy Moore. Appreciate it. And Ali K. And then let's see which is on C here. Oh, and then I think C is just you may be aware that I filed an ex parte motion for funds on February 26th, which contained confidential information regarding our client's defense. We have double-checked and confirmed that the only 2 individuals CC'd on the motion were myself and Andy. This morning, I received an e-notice of filing by Mr. McLeod requesting Dr. Westcott's records, and in his filing, there exist specific quotes from my ex parte filing on February 26th. Unless I'm missing something here, this would suggest that Mr. McLeod has a copy of my motion. Naturally, this is concerning. In an effort to not to jump the gun on this, my staff members did reach out to Karen in Carroll County Circuit Court to confirm that she processed the motion in accordance with the ex parte procedure, and she assured me, the staff, that she did. I am not looking to point fingers here, but I think it's fair for me to inquire as to why our client ex parte filing is not being treated as confidential filing. I also think it's fair to inquire as to why wasn't your Frank's memorandum treated as confidential? Thanks, Esther M. and Cindy J. Yeah, so anyways, this is their filing back then, and now they're using that as, oh yeah, this is prejudicial. So here we go. Let's see, the tutorial Judge Gull emailed to counsel is actually intended to assist court staff and clerks in how to properly handle ex parte documents after the private practitioner has filed the ex parte document. In other words, the document that Judge Gull refers to in her order does not in any way assist the practicing lawyer in filing ex parte documents, as it is a tutorial for court staff. Please find attached printout, that's the Exhibit B that we just looked at. Even though on its face, this tutorial clearly appears directed to assist court staff in understanding how to process, accept ex parte filings, the defense staff still reviewed the tutorial sent by Judge Gull. What's this note here? Whether any part of the tutorial was meant to assist a practicing attorney in how to file an ex parte document, it does not. When defense staff clicked on the link detailed in Step 1 and attempted to sign in, they were presented with a prompt that states, "You are not authorized to use this site." This is because, again, the tutorial that Judge Gull proclaimed to be her order as helpful to the defense was actually meant for court staff. Judge Gull has failed to admonish Prosecutor McClellan for improperly reading ex parte pleadings while continuing to denigrate defense counsel. Thanks, Sandy Shirley. Delighted to have missed something Soto Stern. Okay. Judge Gull's failed to admonish Prosecutor McClellan for improperly reading the ex parte pleading. The pleadings errantly made accessible to Prosecutor McClellan were clearly marked ex parte. The defense became aware that Prosecutor McClellan read the ex parte documents based upon a March 6, 2024 prosecution filing in which the prosecution directly quoted from the defense ex parte filings from February 26, 2024. This document clearly marked in capital letters at the top of the document, ex parte pleading to be placed under seal. After reading Prosecutor McClellan's March 26, 2024 filing and realizing that McClellan had reviewed a defense ex parte document, Attorney Rosie sent an email to Judge Gull and one of Judge Gull's staff members, as well as Nick McClellan. Find attached copy of said email. That's the one we just read a minute ago. The email respectfully questioned how an ex parte motion was made accessible to the prosecution. Then on March 7, 2024, Prosecutor McClellan filed a pleading in which McClellan finally admitted that he also had access to 3 other ex parte filings. Despite the clear markings of ex parte on the documents, Prosecutor McClellan chose to read those ex parte documents rather than promptly deleting them and alert. Yeah, you think you would? Come on. Rosie and Baldwin, you guys are scumbags of the earth, releasing crime scene photos. Properly deleting them and alerting the defense of the misdirected filing as required under Indiana rule professional conduct. A lawyer who receives a document related to the presentations of the lawyer's client and knows or reasonably should know that the document was inadvertently sent shall promptly notify the sender. Prosecutor McClellan never contacted defense counsel after receiving the ex parte documents as required under IRPC 4.4b. The defense only learned of this violation upon reviewing McClelland's March 6, 2024 pleading, in which McClelland audaciously quoted directly from the ex parte document, thereby making said quote available for public view. The act of McClelland reading from defense ex parte documents provided the prosecution with an entirely improper glimpse into the manner in which Mr. Allen's attorneys would be defending him. This is yet another example of a subversion of Richard Allen's due process rights. This court has failed to reprimand the prosecution for reading ex parte documents or to even address that issue in any way whatsoever, nor has Judge Gull filed a pleading in which Judge Gull, publicly proclaimed that she is referring Nick McClelland to the Office of Judicial and Attorney Regulation Execution Director Adrian Meering for that office to enforce the rules or determine counsel's ethical misconduct. This court publicly declared in its April 30th, 2024 order that it was referring defense counsel to the Office of Judicial and Attorney Regulation concerning a short and bland press release that defense counsel sent out to media sources then when no gag order was in place and after the prosecution and law enforcement had conducted multiple press conferences and issued multiple press releases over the course of the investigation. Meanwhile, on the much more serious allegation of McClelland reviewing ex parte documents and violating IRPC 4.4, Judge Gull has said or done nothing. Judge Gull is clearly treating the prosecution differently than defense counsel, and this provides a rational reference for bias. The court offered its hand-picked public defenders an opportunity for a hearing on the Franks motion, but denied the same opportunity for attorneys Baldwin and Rosie. This court offered its hand-picked. Well, you guys were hand-picked, remember? In her May 31st, 2024 order denying the defense request for disqualification, the court maintained that it has no bias against defense counsel. On January 22nd, 2024, this court denied Baldwin and Rosie's request for a Franks hearing. At that point in time, this court has failed to rule on the Franks request for over 4 months. Yet within 4 days, they're re-entering their appearances Yet within 4 days, they're re-entering their appearances on the case. Judge Gull denied their request without hearing. However, after Baldwin and Rosie were taken off the case in October of 2023, Judge Gull informed her newly hand-picked public defender that they should review prior counsel pleadings and either adopt those pleadings or make them their own. In that November 14, 2023 CCS entry, it was memorialized that Judge Gull informed the new public defenders, those two temporary ones, that if defendants' new counsel informed the court they intend to pursue the Franks motion, the court will schedule a hearing. Such action demonstrates that this court is punishing Richard Allen due to her bias against attorneys Baldwin and Rosie, in that after they re-entered their appearances, she quickly denied Allen's original counsel a hearing on the Franks motion while offering the replacement public defenders an opportunity to have a Franks hearing soon after their appearance on the case. What do you guys think of that? Thanks, Amy Moore. Look at that. She's trying for a wave. Will it work? Will it happen? We just don't know. No, I think what they're saying is Judge Gull denied the Franks motion by Baldwin and Rosie And then when those 2 temporary lawyers came in, she would grant them a hearing on that. But when they were removed, she denied Baldwin and Rosie again. Maybe it might be the way that they were going to do it. Come up with your own Frank stuff. The stuff that they were doing was complete. So Baldwin and Rosie's Frank's motions were denied based on information, not just sort of summarily denied. All right. Well, we're currently at about 40%. 40%. Such action demonstrates that this court is punishing Richard Allen due to her bias against attorneys. This desperate treatment of attorneys Baldwin and Rosie, compared to this court's treatment of the prosecution and even one of the replacement public defenders, provides a rational inference of bias against the defense counsel, Baldwin and Rosie, and therefore again against Richard Allen. In its order, this court claimed that it is irrational and unreasonable for the defense to assert that as lawyers with 70 years of combined experience, they have never had a judge provide a hard end date for a trial. Calling defense counsel irrational and unreasonable shows a bias, especially when the court is wrong in its understanding of Jury Rule 4. This court unfortunately continues to malign defense counsel by calling them irrational and unreasonable for their averments that courts around the state of Indiana never set a rigid day for the trial to end. Implicitly, the court is also averring that defense counsel are lying about their experiences in other courts around the state of Indiana. Furthermore, this court maligns defense counsel concerning its knowledge of the jury rules when it is the court that is incorrect, you probably meant, in its assessment of the jury rules. At the May 7, 2024 pretrial hearing, the court stated, well, you understand, well, maybe you don't understand, Jury Rule 4 requires that I issue summons to the jury with the dates that the trial dates of the trial. Jury 4, Rule number 4 requires that I issue summons to jurors with the dates. Transcripts, May 7, 2024, hearing, page 12, line 13. The court cited Jury Rule 4 as a bias for limiting the time of the trial. However, Jury Rule number 4 not ever discuss the length or dates of the trial or requires court to place a hard end date for a trial. Jury Rule 4 states that not later than 7 days after the date of the drawing of the names from the jury pool, the jury administrator shall mail each person whose name is drawn a juror qualification form and notice of the period during which any service may be performed. Jury Rule number 4 is primarily referring to the time span or term during which citizens need to be on the alert that they could be summoned in for jury duty. Example, when they are on call for possible jury duty, the prospective juror needs to be aware that over the course of a specified number of months, the court may summon them to appear in court as a potential juror at a later date. Jury Rule number 4 further states that when summoning a prospective juror in for jury duty, that the summons shall include the following information: directions to the court, parking, public transportation, compensation, court policies regarding the use of electronic communication devices, i.e. cell phones, PDA smartphones, etc., tire meals, and how to obtain auxiliary aids in services required by the American with Disability Act. Yeah, we're getting crushed because I'm reading tonight. If I was doing the whole show again, it's just... Now, we're not even really at 40%. We're at 93, and 250 is the goal, so just sort of one of those struggling nights, I guess. Number 64, note that jury rule number 4, jury rule number 4 3 times fast. I mean, there's almost no way to get that out. That's ridiculous. Even twice. Jury rule number 4. Jury. I did it, Gray. I really did. I'm sure you did. Nor does jury rule number 4 require the prospective juror to be advised of the beginning date or end date of the trial. Jury rule number 9, term of jury service states a person who appears for service as a petite juror serves until the conclusion of the first trial in which the juror is sworn, regardless of the length of trial or the manner in which the trial is disposed. Once summoned in and selected as a juror, juror rule number 9 is the jury rule that comes the closest to referring to the length of the actual trial. Note that jury rule number 9, but see, here's the thing. See, Sandy Shirley goes, bummer. Well, you're the one that wants to do other cases other than the big ones, Note that jury rule number 9 places no limit to the length of actual trial once a juror is selected, nor does jury rule number 9 place a hard end on the conclusion of any trial. Indeed, by stating that the juror serves until the end of the trial, the first trial, regardless of the length of the trial. The authors of the jury rules innately understand that courts will not have foresight to include the... I'm not sure I'm really that interested in learning about jury rules. Let me skip past any of this shit. How about right here? Is it Judge Gull errant interpretation of Indiana jury rules created a situation in which Mr. Allen was required to seek a continuance of his speedy trial in order to assure for himself a trial where he could thoroughly present his defense without time restrictions. Judge Gull's bungling of Mr. Allen's speedy trial due to her misunderstanding of what the jury rules require in the summons only negatively affected the defendant and its constitutional rights, not the prosecution, and thus provides a rational inference of bias. Additionally, at the May 7, 2024 hearing, Judge Gull cited several cases over which she had presided that lasted less time than the defense is requesting in this case, essentially chastising the defense for the amount of time it was seeking for trial. The length of a trial is determined by the number of witnesses, the amount of evidence, the length of the investigation, and the complexity of the issues involved. This is the case of State of Indiana versus Richard Allen, with its own set of facts, challenges, and potential pitfalls that could cause the trial to last beyond what the parties expect. For example, several witnesses reside 125 plus miles away. If those witnesses fail to appear in spite of being properly subpoenaed, the trial may be delayed while the parties try to determine how to deal with a witness whose car may have broken down or who may have simply ignored a valid subpoena. The situation arises in trial, especially in a factually complex trial with approximately 185 witnesses identified by the parties. That's ridiculous. Additionally, of the approximately 185 witnesses identified by the parties, a dozen or more are expected witnesses whose testimony will generally take longer and will be more complex than fact witnesses. For this court to call defense counsel irrational and unreasonable for stating the truth that they have never had a judge set a hard end date to a trial. Yeah, I've never heard of that either, to be honest with you. It just seems like you have a trial and, what do? Just stop it right in the middle of it, I think you just kind of go as long as it goes, I mean, obviously you can't just, you should have a reasonable amount of time. And if it's supposed to be 6 weeks, maybe it goes 6.5, but you don't just sit there and... For this court to call defense counsel... Okay, additionally, it is shocking and disconcerting that the court refused to place a limit on the time allocated to the prosecution, but absolutely limited the time for the trial, thereby limiting Mr. Allen's time to present his defense. Okay, so that would never happen. So if the prosecution took 10 days and the trial only lasts 11, they're not going to go, well, that's all you got. It never happens like that, But anyways, any chance you guys could help support the channel tonight? We got to keep we've been doing well this month. I know I tried to switch to something else because, people like Sandy Shirley and other people have been saying, hey, I don't really, I don't want to keep talking about the Madelaine Soto case, and so I figured I'd try something else. Unfortunately, what we're stuck with is this document to read. That's what I wanted to go over to see if there's anything interesting in it, because I don't have time to read the whole thing, then do, so I'm reading it with you guys. Or maybe it wasn't Sandy that said that. I think it was that Ginger? Now I can't remember. I don't remember at this point who said that they didn't like, that they wouldn't be watching. Right. But why is it such a struggle again tonight? I mean, it doesn't have the bells and whistles, is that it? Or... Well, I didn't remember who said that, Ginger. I can't remember who... Now I can't remember who it was that... I think it was the voice messages. I think it was Sandy. Okay, Sandy said it. Yeah. It was Sandy Shirley. Yeah, she's the one that said she wanted to do something else. So, trying something else, but look how I'm getting punished for it. That's the whole thing. You gotta do it that works for the channel. Additionally, it's shocking and disconcerting. Okay, under the court prior order, the trial was to last from May 31st, 2024 through May 31st, 2024, thereby allowing approximately 13 days for opening statements, testimony, evidence, rebuttal evidence, surrebuttal evidence, arguing of final instructions, and closing arguments of both parties. If the prosecution took 8 days to present their case, this would only leave 5 days for Mr. Allen to present his witnesses, which include at least 5 expert witnesses without even factoring in rebuttal evidence, surrebuttal evidence, arguing of final instructions, and closing arguments. The hard limit on the end of the trial denies Mr. Allen his Sixth Amendment right to confront witnesses, his Sixth Amendment right to the compulsory process for witness, and his 14th Amendment due process right to present a defense. In the context of its request for Judge Gull to disqualify herself, this court maligning of defense counsel as irrational and unreasonable, when in fact it was this court that was wrong in its understanding of jury rule, and also wrong in its claim that court statewide provided a hard end date to a trial, offers a rational inference of bias. Thanks, Michelle H. Judge Gull, May 31st, 2024 explanation for denial of defense motion without a hearing provides a rational inference of bias. Thanks, Wendy Van Rocco. Well, that's okay, Ginger Keys. I was talking about people didn't want to just keep talking about the same case, but I mean, I like talking about the Madelaine Soto case now because there's so many, all those documents that came out. There's different things that you can think of, little elements that you put together on a daily basis. So for me, it's interesting, you know. Has the defense team muddied the jury pool? I mean, I'm sure that whole Odinist story is all around the area. No, I'm saying, Sandy, a minute ago you said, "Oh, that's too bad," but I'm doing this for you. You know, you didn't want to keep going over that case, so I thought I'd do it for you. Right, I get what you're saying, but you know, we're doing this show, and then look how it is. That's what I'm trying to say. It's kind of frustrating. Yes, well, it's kind of weird how it's like that, Sandy, but it is like that, unfortunately. It's kind of weird. I don't know. But anyways, we're on page 15, so we're almost done. I gotta check something out, though. No. Okay. Yeah, it's okay. I thought it got more interesting lately, though, because what I'm trying to do is figure out if there's any, you know, digging around in the Stephen Stearns case to see if there's anything at all that points to Jennifer. That's what I'm looking for when I'm doing all these. Like, I don't have a bias, you know. I'm just doing the ping information, looking at it, trying to see if there's anything that points to Jennifer, and haven't found anything yet. And then seeing if there's any other stuff, you know. No, it's okay, Sandy. You know, I mean, it's no big deal. I was just reading up there when you said, "Hey, is he at the Gull?" And they said no, and you said, "Bummer." You know, it's like, yeah, I know why I'm not at the Gull, because I'm not covering that case. You know, that's exactly why. So anyways, it says, Judge Gull's May 31st, 2024 explanation for her denial of defense motions without a hearing provide a rational inference of bias. In its May 31st, 2024 order, when explaining why the court denied several defense motions without hearing, the court stated, if pleadings on their face are not supported by the law or admissible evidence, judicial economy does not require a hearing. This court knows very little about this case, especially compared to the lawyers litigating the matter. Therefore, how could this court determine what evidence would be admissible or inadmissible until a hearing takes place and the defense moves to admit the evidence, subject to possible objection by the prosecution? Judge Gull's claim that defense evidence is inadmissible before conducting a hearing and before listening to the defense contextualization of the evidence surrounding their legal arguments provides a rational inference of bias against the defense. The court's denial of defense motion without a hearing based upon the reasons this court cites in its May 31st, 2024 order establishes that the court is prejudging defense evidence as inadmissible. Also, this court claiming that the law does not support the defense pleading before this court even hears any evidence is additional proof that this court is prejudging evidence. The court's denying the defense's request contained in its pleading without a hearing based upon the prejudging evidence provides a rational inference of bias. In the future, if the court denies defense motions based upon the court's belief that the defense pleading is not supported by the law or admissible evidence, the defense then requests this court to identify the evidence cited in the defense pleading that this court believes is inadmissible, and then to explain why the court believes the evidence is inadmissible. Also, this trial isn't going to happen for a long time, in my opinion. I mean, just think, then eventually they're going to say, yeah, I'm denying this, and they're going to have, motions to allow this certain type of evidence, and then it's just going to go back and forth. It's just not happening. Even concerning something as basic as a request for a recess, Judge Gull shows favoritism to the prosecution. In her May 31st, 2024 order, Judge Gull expressed that she does not show favoritism to the prosecution. However, Judge Gull has shown her differential treatment between the prosecution and defense in a variety of ways. Some are easily identified and some are less perceptible. For example, because cameras have not been allowed in courtroom, it is difficult to hear Judge Gull's angry tone when addressing the defense versus how she speaks to the prosecution, and also to visualize the court's disdainful facial expressions she makes towards the defense versus the prosecution. God, what a bunch of crybabies here. Although it may seem petty or trivial to the court, the defense offers an example of her disparate treatment concerning something as mundane as how the court handles a simple request for a recess during a hearing. At the June 15, 2023 hearing, Prosecutor MacLeod requested a recess, and the following transpired. MacLeod said, "Judge, I have 2 witnesses. Can I ask the court for a short recess just so I can use the restroom?" And then Judge Gull said, "Would counsel approach?" Sidebar conference conducted. Judge Gull said, I just want to know kind of where you're at. You've got 2 witnesses." So this is MacLeod, though, that asked for it. MacLeod said, "Tony Liggett and Westville Warden." Judge Gull said, "Okay, do you want a break for lunch?" Rosie said, "I don't, but Judge said, "Okay." MacLeod said, "So I don't care, I can." Then Judge Gull, "Yeah, we can take a quick break. How long?" MacLeod said, "I don't mean to be a pain," but then Judge Gull said, No, that's all right. How long do you think you'll be?" MacLeod said, "Downstairs and right back up." Judge Gull said, No, I mean in your witnesses with your evidence." "Oh." Judge Gull, "Ding dong." Let's see. Judge Gull said, "Ding dong, I don't care how long it takes you to go there." "No, I don't care about that." Is she calling him like a ding dong? I don't know. Then MacLeod said, "I don't really think too long, Tony, about the transportation resources," and then Gallipo, just to address allegations they made in their safekeeping. And then Judge Gull said, "So like another hour and a half, I guess. I just couldn't, let's break for lunch. I know you don't want to, but too bad." Rosie said, "I'm fine with whatever." Then Judge Gull said, "Okay, let's just break for lunch." Rosie said, "I don't have anywhere else I need to be." Judge Gull, "Well, I know you don't because you were supposed to be here for 2 days." And then it says 88. However, at the May 7, 2024 hearing, the court treated the defense much differently when the defense sought a short recess to confer with their client on urgent matters concerning the positive-negative continuing Mr. Allen's speedy trial due to Judge Gull's hard end date of May 31st, 2024, following a back-and-forth exchange between Judge Gull and defense counsel concerning the defense needing more time for trial, then Judge Gull allowing... So how can you... I hope they're not going to try to compare the way she sounded when he said, "Hey, can I have a few more minutes here? I got to use the restroom." to trying to get more time for a trial. I mean, that's like a totally different thing. And then Rosie said, "Can we have a 5-minute recess?" She says, "Why?" Rosie said, "I would like to speak with my co-counsel here and have a discussion about the business issues such as scheduling, not here in a courtroom where everybody's listening to us. We've got, 50 staff members in the courtroom, people sitting behind. There's no privacy, and I'd like to talk to him in the hallway about some of the logistics of," but notice how his answers are so long too, like just something so simple. "There's no privacy, and I'd like to talk to him in the hallway about some of the logistics of this so we can solve this problem so that he, Mr. Allen, can put on a defense." Judge Gull says, "Does the state of Indiana have any objections to a recess?" MacLeod said, "No, Your Honor." Judge Gull said, "All right, Jody can go off the record." Judge Gull did not playfully call Brad Rosie ding dong. Jeez. These guys, that's all you had? I thought this is a really polite interaction right here. Look at that. That's totally polite. I mean, it was perfectly polite. There was nothing mean. "No, Your Honor." "All right, Jody, can you go off the record?" And then he's like, "You didn't call him a ding dong either." God, are you kidding me? That's what you're talking about here? See, that's what I'm saying. These two attorneys are wackos. Can you believe this? Judge Gull did not playfully call Brad Rosie a ding-dong, but instead questioned Rosie. "What do you mean?" "Go back up here. She said the same thing." Look at this. He said, "Judge, I do have 2 witnesses. Can I ask for the court for a recess? Would counsel approach?" Judge Gull, "I just want to know what kind, and so she's questioning him. It was actually a lot longer, and, this is ridiculous. I hope all of you, like pro Richard Allen wackos, when you read that, lost all faith in that defense team. Judge Gull did not playfully call Brad Rosie a ding-dong, but instead questioned Rosie's reasons for seeking recess. Then Judge Gull surprisingly asked the prosecutor if he had an objection to seeking a 5-minute recess. Okay, hold on. Would counsel approach? And that says, "Okay, do you want a break for lunch?" "I don't." And there was one time she said, I think she did speak to the defense team up here. "I'm fine with whatever." Judge Gull, "Let's just break for lunch. I know you don't want to, but too bad. I'm fine with whatever." Okay, but see, he was just interjecting there was no need to ask him anything because he was just answering it. Thank you, Jessica. And hey, we just hit the 40% mark. Finally. Wow, man, that's almost scary. That's what you. Judge Gull did not playfully call Brad Rosie ding-dong, but instead questioned Rosie's reasons for seeking a recess. Then Judge Gull surprisingly asked the prosecutor if he had any objection to seeking a 5-minute recess so that defense counsel could talk to their client about the important matters concerning seeking a continuance of a speedy trial due to the trial court's unwillingness to provide more time to the defense at trial. When a defense attorney requests a 5-minute recess to talk to their client on such weighty matters as their constitutional rights related to continuing a speedy trial, it should be met with a simple "of course" and should not require approval of the prosecutor. It probably didn't. She was just seeing how people... Yeah, God. The fact that Judge Gould treats the defense differently on such a basic matter as... There isn't any court that would read that and feel sympathy for Brad Rosie. They would look at that and go, you guys are freaking babies. Like, what are you talking about? This court failed to address the appearance of bias which exists in this case. Judge Gull claims in order, as counsel should know, criminal cases are tried in court of law, not in court of public opinion. However, the standard for recusal is not just whether actual bias exists, but also whether the appearance of bias exists. The judge must consider both actual bias and the appearance of bias when determining whether to disqualify yourself. Judge Gull appears to conflate the general concept that, on occasion, the public will vehemently criticize a judge with the defense specific contention that many in the public are particularly criticizing her for what the public perceives is actual bias against the defense. That's because you're creating the illusion. The emails which the defense attached to the motion and the memes the defense referenced in the motion detail how the public believes that Judge Gull's bias against the defense. Yeah, you're getting all your little buddies to make memes, and you think that's going to mean something? The defense agrees with the court that general complaints by the public concerning the court's ruling should not cause her to disqualify herself. However, that is not what the defense is discussing in its motion. Although the defense believes actual bias exists in its appearance of bias against the defense, about which the public has complained, it is the appearance. The public is only complaining because you guys are pretending there's bias. They didn't even notice anything on their own. It's you pretending it, and it's all bogus. It's been argued and reversed out. It is appearance of bias against the defense about which the public has written the Indiana Supreme Court is the appearance of bias against the defense about which the public has written Judge Gull. How do you know? And it is the appearance of bias against the defense, the existence of which Judge Gull should recognize and for which Judge Gull should voluntarily recuse herself. Failure to address other issues contained in the first motion to disqualify. The court addressed a few other defense issues contained in their second motion to have Judge Gull disqualifying herself. The defense stands by those reasons as well and does not waive those issues for purposes of appeal. However, in its May 31st order, this court failed to address all issues contained in the defense first motion to have Judge Gull disqualified, which the defense incorporated into its second motion. The defense requests Judge Gull to review the first and second motion to disqualify and consider whether she feels obligated to disqualify herself from this case based upon the itemized reasons contained in those motions as well as in this response. The conclusion is the defense wishes to move forward and have this court conduct hearings, most immediately the request to have Richard Allen removed from the DOC to either CASS or Tippecanoe County jails while awaiting trial. The motion is intended to respond to Judge Gull's order for purposes of preserving the issues for record and so that Judge Gull may consider whether or not she feels obligated on her own to recuse herself from this case, which remains an ongoing obligation, whether or not the defense is seeking her recusal. Wherefore, the defense files its response to Judge Gull's May 31st, 2024 order of judgment of the court concerning her denial of the defense request for disqualification. And there you go. All right, well. God. These guys, man, this is never going to take place. You know, they're going to have hearings. She'll rule one way. Then instead of just accepting it and moving on, they'll send another, document in to try to get that reversed and just keep going and going and going and going. But so, all right, you guys, we're just still sitting at 40%, and it was because of the reading. Scary times. Would you take offense if someone called you a ding dong? Yeah, I mean, I wonder how she said it. Like, oh, you ding dong. I was talking about. See, the difference is like you got these prosecutors that work with the judges a lot, so they know them better. You know, the defense attorney probably doesn't know them, and their behavior's been abhorrent. So it's pretty easy to, you know, not have the same sort of, hey, you know what you should do? Walk in next time, and Rosie asks a question, and she should go, come on, Buttercup, you know that, just as a joke. See what he would do. you ding dong. But anyways, all right, guys, I think that's going to do it. Short show tonight. Thank you for being here. We got the Cheryl Bullock, Dan H, Esther M, Robin Berardo, Donna Aldridge, Snow Remover, 8675309, Allie Cake, Michelle, Lisa Valenzuela, Justin Oakley, Jessica Schubach, Amy Moore, and Allie Cake, Esther M, Cindy J, Sandy Shirley, Amy Moore, Michelle H, Wendy Van Rokel, Jessica, and Amy Moore. All right. Thanks, everybody. We'll see you guys another time. All right. Yep. But great. Oh, thanks, Ginger, for the PayPal there, but we're still not even at 50%. So, all right, you guys, we'll see you next time. And as I always say, what do you mean no? How come you're saying no? What's going on? I can just tell this is one of those nights. I'd rather work on a video and, you know, keep churning out videos for people to watch because the show isn't, you know, unless I'm doing the big cases, it doesn't work. So, all right. So thanks, everybody. We'll see you next time. And as I always say, until that time, be safe out there. And a 1 and a 2 and a 3 and a 4.
Yeah, I've been
Who
doing
knows?
this
Maybe
true
late at
crime
night
for
I'll come
quite a
back
while
on.
now.
You never know.
And during this whole time, I have not seen one person that is a crime dissector, flag rejector. I'm a certified human lie
Thanks, G.
detector.
Look at
Gonna
that.
get ya on a stretcher if you try and play me like an old projector. Crime sector is my nectar. Professor Grego's gonna give another lecture. Crime collector, freak connector, and I'm always gonna be a protector.
Hey, no problem, Sandy Shirley.
Good
to see ya.
And I'm meaner than a spectre with a
Vector on his pector with all respect, y'all. Just remember,
I have a temple fucking
check show. I have no agenda.
I'm a pretender. And I'll serve it to you straight without a blender.
And in the end, I'm gonna send you on a mission to reveal the true offender.
Yeah, so I'll just get right back to work. All right, everybody?
Hey, thank you very much up there, Judy Grandstrand. Well, the thing is, I might come back on later, but it's hard to, you know, when you have a thumbnail and you're doing the Delphi case and then just to switch over to something else. So maybe I'll come back on it. Well, it's already kind of late, isn't it? Jeez. It's already 8:43. So anyways, we'll see. You know, maybe at 10 o'clock I'll try to do something, or you know, do like a 2-hour live stream on what. And by the way, what's tomorrow? This holiday for tomorrow? Like, it's just crazy. Juneteenth. What the hell is that? I just noticed that the stock market's closed. Man. Oh, I'm just it was just kind of dead in here. I'm gonna go. I'll probably try to come back later, and then I can change the topics because we just read the whole Delphi document. So to switch over to something else, people wouldn't know that I'm talking about that. You'd have to change the thumbnail and everything. So maybe I'll come back on at 10 for whoever's awake. That'd be 1 in the morning for the East Coasters. You know, see how it goes. Maybe even 9:30. Do something else. What'd be cool is to go on and do a show, and you guys tell me all the things that people are saying. You know, and try to debunk them. I want to make a debunking video. Yeah, they're doing the same shit. This trial, I bet you the Delphi case doesn't go to trial for forever. I mean, it's going to be like next year sometime. It just doesn't feel like the defense is even anywhere near, you know, anything. No, the slavery end. Is that what it's actually? What? Let's see. Is that really what that is? I mean, isn't there already like when you think you'd combine that with like Martin Luther King or something like that? Let me see. Let me just look it up. I don't even know. I just started hearing about it. Independence Day is a federal holiday in the United States. It's celebrated annually on June 19th to commemorate the ending of slavery. So that must have been with like Lincoln, right? Something like that. I'm sure people will find a way to make him into a racist, though. Yeah. Well, that's pretty good to have. Yeah, not a bad reason to have a holiday, I guess, or a remembrance. January 1st, 1863, the first watch night services took place. On that night, enslaved and free African Americans gathered in churches and private homes all across the country, awaiting news that the Emancipation Proclamation had taken effect. I wonder if there was like people were really nervous waiting up to the last minute until that was signed. Yeah. Well, that's pretty cool there, though. You know, that's a good. I guess that's a good. They should probably have it a different name, though. I'm not really into the name. You know, make it something more meaningful. You know, like call it like Freedom Day or something. You know, it's just kind of like it's so. You know, maybe it's meaningful to some, but the name itself needs to be more hitting. Like, you know, Freedom Day. You know, just kind of like Juneteenth. It's sort of a, you know, kind of what day you're talking about. You know, should do a funny segment on Proctor. Yeah. Anyways, all right. So maybe I'll come back on a little bit later, you guys. See you guys later. Thank you very much. Have a good one. Be safe out there. You never know.